Hi everybody, it's the quick video update time to give you the most efficient update on important new forms. Who else gets excited by contract revisions? So the WEBforms and repree have just been updated by area with new contract forms. You would have got an email on the 17th last week, so it was last Tuesday, of that update. So the main forms that have been updated are the residential purchase contract, the two supporting forms, and then there's two new forms that are related to realtors' conflict of interest. So if you have an interest in a property in some capacity. So I'll breeze you through these updates. I'll also put a link down below on the video here and on the post so that you can go through it if you want more detail or if you missed that email from area. So the purchase contract changes to residential, country residential, and resale condominium purchase contracts. Section 2.4, this clarifies seller warranty. It adds that the seller represents and warrants that the condition on completion day will be substantially the same. By adding it as a seller's warranty, it now continues beyond the completion day. So if you discover something a week later that isn't substantially the same as it was at time of viewing or on possession, then they're still liable for that. Section 4.5, late deposits. The seller might void the contract, is the existing term, if the buyer doesn't deliver the deposit by the agreed upon time. But the seller's option expires whenever the seller accepts a deposit, even if it's late. So they've added in terms to clean up that term, basically. Section 4.9 was deleted, so this related to disbursements of trust deposits. Basically was in contravention to the Act because it said that there was no liability for losses related to trust deposits, which is not the case for brokerages. We have to account for all trust monies. Section 6.1 E and I. So this is regarding encroachments and easements. So since 2006, when the last contract revisions were done and published, areas learned that some approved municipalities encroachments are not registered on title in order to allow the municipality to be able to alter their policies in the future. So in those cases, they basically changed the wording because of that type of encroachment to deal with that clause. It's suggested to still ensure that you're asking the seller for any encroachments or agreements as part, especially in like rural situations. Section 6.1G. This is regards to sellers, reps, and warranties of known government and local authority notices. So this clarifies wording because there's been some ambiguity when it was tested in court. It's known to the seller. So that's what's now been added. It's still advised to, when representing buyers, that you do your own due diligence and confirm any lack of permits or other local authority notices. You can do searches at the city, whichever municipality it's in. So you want to do that extra diligence for your buyer, but this wording has been cleaned up just to clarify that it's to the seller's knowledge that there is none. Section 7.1, this is regarding dower rights and signing timelines. They basically now added in that the buyer's option expires when the seller delivers the dower consent. So similar to the deposit term that they've added, they've now stated if you, the seller could back out of the deal, basically, if they didn't deliver, or sorry, the buyer could back out of the deal if the seller didn't deliver the dower consent form by the agreed upon time. But if and when they do deliver it, if you haven't given notice as the buyer to the seller that you wish to terminate the agreement, then all contract terms stand. Sections 10.3. So this is closing payment term. Basically, they removed the ability for electronic funds transfers between lawyers. It has to be done by certified check or certified funds. The basic feedback was from the Law Society that there's provisions in situations where law firms cannot meet this requirement to specifically when it's an unrepresented client. So they've removed that ability for electronic funds transfers. So we'll see how that plays out, and we'll get some lawyers' opinions on that as far as logistics with closing and how to prep your clients for that. So attend the next sales meeting, and that'll be one of the topics. So that's it for the purchase contracts. So everything else is substantially the same. They've changed the branding on top. It says areas, new branding, but those are the key terms that have changed. So purchase contract dower consent acknowledgement. This is the separate form, and they've altered this, specifically clarifying who is an officiating officer. This primarily is just applicable for out-of-province clients or spouses, because there's different officiating officers that can sign that dower consent form in different provinces. The other term or contract that schedule that got changed is the sale of buyer's property schedule. So clause 1.8 is a new addition. If the buyer gives written notice waiving the sale of the buyer's property condition before the seller provides the seller's notice to waive all of the buyer's conditions under 1.6, then the condition date for any conditions will be as agreed in the contract. So that's the new term. So impact of this, it balances the rights of sellers and buyers. Buyer can now stagger conditions such that if they remove the seller buyer's home conditions and they still have financing and home inspection or condo doc review at a later date after the sale of their home, those remain in full force. It's my opinion to attempt when representing a seller to negotiate terms where they would remove property inspection, financing subject to the sale of their home, etc. beforehand. So really I don't think it has impact other than in situations where you've negotiated and allowed for time after the sale of their home to deal with other conditions. So once the buyer removes that condition of the sale of their home, the other conditions stand. There was confusion with the previous contract wording. New disclosure forms. So this is for use by realtors when there's a conflict that exists. So there's two new forms. First form is a realtor's disclosure statement to a represented person. The second one is a realtor's disclosure statement to an unrepresented person. So best practices and advice for these forms, we'll go over them at the next sales meeting as well. I'll put them up on the screen, but determine the situation and use the right form. So you need to understand if you're representing a seller already and it's an unrepresented buyer that's coming into place on a property that you have an interest in that you're selling, or that you're buying a property for yourself and it's a mere posting seller, or it's listed through another realtor. Those are different situations. Or it's a for sale by owner, for example, or a private sale. Fill in all of the blanks on these forms, inserting like an NA or not applicable in spots where it doesn't apply is suggested, because it then doesn't leave room for ambiguity in the courts or by RECA if they're not mistakenly were missed or left blank. Honor the rights of the other party to seek legal or independent advice. So the key to this is structuring the timing of your purchase contract to allow them time to have independent advice. If you're a licensed person and you're selling your own property and a buyer approaches you about entering into that directly or as an unrepresented buyer, you need to make sure that you have them sign off on this disclosure form and do not have them sign the purchase contract within a reasonable period of time based on the circumstances and the market conditions for them to get independent legal advice. So protect yourself by ensuring the other party's signature on the disclosure form is dated prior, so before their signature on the purchase contract. So if you submit that or do the disclosure form after the fact, it's basically useless because you did not provide that client or that customer with enough time and with the ability to review their situation and seek independent advice. So that's the onus we have as realtors, is to make sure that we're providing neutral third party and disclosing any conflict of interest. So this is if you have a partial interest in the property, if there's some financial benefit that you receive from the sale of it, other than a commission obviously. So you have an ownership type interest on the buy side or the sell side. And that's it. So they're pretty easy changes, and hopefully that gives you a nice summary of what they are. And reach out to myself or any of our management team if you have other questions, or comment below and we'll clarify for everybody. Have a great week, and we'll see you at the sales meeting Thursday, August 10th It's Dairy Queen's Miracle Treat Day as well, so we'll be getting blizzards from around the corner at Old Strathcona here, and so who doesn't love ice cream and learning? See you soon. Bye.